I'm Scott Graham. I'm the director of the Illinois Landscape Contractors Association. I want to welcome you all to today's webinar, Class Action Waivers, Arbitration, and How It Can Impact Your Business. Yeah, every year I get dozens of calls from members who just received some scary piece of paper at their office. Oftentimes they'll tell me it's from the U.S. Department of Labor, and I'll breathe a sigh of relief knowing that it will be a nuisance, but it's something that they will ultimately get through. Other times it could be from the Illinois Department of Labor, the Illinois Department of Employment and Security, the EPA, IDR, etc. And I know that, again, they'll get through it and the member will prevail in the end. But the one that makes me wince is when I hear they were served by a labor attorney. At that point, I tell them to brace themselves because it's going to be a bumpy, frustrating, and very likely a costly ride. For years, labor attorneys have haunted the landscape industry. Companies often suffer alone out of fear of embarrassment or harm to their reputations. And the legal actions and resulting class action lawsuits can cost employers hundreds of thousands of dollars in settlements. For years and years, employers have skated by on their strong HR policies, company culture, and in some cases, just pure dumb luck. Now, recently, the U.S. Supreme Court ruled that employers can require that employees resolve employment disputes through binding arbitration. So this ruling will permit employers to forego costly court cases, including class actions that have been filed against many members of the ILCA in the past. This webinar will discuss this court ruling, what arbitration is, how it can be implemented, and how it can benefit you as an employer. Today, we're joined by David Ritter of Barnes & Thornburg. David has been our preeminent resource within the ILCA on these types of lawsuits. Within minutes of the SCOTUS decision, he was already communicating with me about how best to convey this information to ILCA members so we can protect their businesses and their employees. David will walk us through the process, and he is going to leave time for questions at the end. Questions can be sent using the box. I thank David for his diligence and his attention to this complicated issue, and hopefully he can demystify this process and offer some solutions for your businesses. I now turn it over to David and thank him.
Scott and I were working on an arbitration policy because in the Seventh Circuit, where you all sit, because the Seventh Circuit Federal Court of Appeals covers Wisconsin, Illinois, and Indiana, the law was still favorable with respect to arbitration. And, Scott can back me up on this. Within a week, not more than two of us, finalizing an arbitration policy, the Seventh Circuit issued a decision that cut our legs out and would not support these sorts of arbitration decisions. And I said to Scott, let's just wait. There's a disagreement within the courts, and what we need is the U.S. Supreme Court to weigh in on this. I was confident that the U.S. Supreme Court would rule in our favor, which it did in May, the end of May, in this Epic Systems case we'll talk about a little bit today. So now the legal piece of this has melded with a practical aspect of it, and that's what we're going to talk about both. And the point is how does this impact your business? How do we get out from under, have a good tool in the toolbox to get out from under these wage and hour class action lawsuits? So we're going to talk about all of that. With respect to questions, you have your chat box. There's no reason for you to wait till the end. I'm monitoring it as we go, and I'm more than comfortable to look at that and answer questions as we go along. So feel free to type in questions as we go. And also after the seminar is over, you have my contact information on the first slide. You can email me or call me. No one's on the clock here. Just give me a call because you may have some other questions. You may you may want to consult internally, and then you may have some questions. So just give me a call or shoot me an email, and we can address those questions as well. So, all right. So moving on. So usually the first slide is what are we going to cover today? Well, the problem of class action lawsuits with landscapers in northern and northeastern Illinois. I don't have to tell you about that much. We all know that is a significant issue. That there are certain plaintiffs and plaintiffs lawyers and plaintiffs law firms that focus on your specific industry time and time again. They've been a scourge to you guys, and we need to have some better defensive actions with respect to those lawsuits, and now we have it. We're going to talk about this Epic Systems case and how we can address that problem, and how you, as landscape contractors, can use that decision to your advantage. And I want to stress, as it says in the slide, this is a real opportunity for landscape contractors to take affirmative actions that can really protect your business. And I don't think this is overstating it, but virtually eliminate these sorts of class action lawsuits in courts. So moving on. So what's the problem? The problem is that all of these federal and state employment laws, we all know what they are. There's the Fair Labor Standards Act. You got to pay minimum wage. You got to pay overtime. Skipping to the Illinois Minimum Wage Act, you got to pay minimum wage and overtime. Kind of duplicates what the federal law does. Then the Illinois Wage Payment and Collection Act. That's when we have all those fund laws and regulations that require you to, as employers, to jump through quite a few hoops. And if you want to make deductions, a lot of folks have deductions for uniforms, things of that nature. And we're supposed to have forms, and the regulations are not clear. The case law is even less clear, and it's very easy to make a small language error on a form, and for these plaintiffs' lawyers to glom onto the form and see a small language error, and then they're off to the races. They find one plaintiff, and before you know it, since that form applies to everybody, we have a class action lawsuit. And I know people were raising their hand and testifying, and the damages are zero or close to zero, but yet you're paying, a ton in legal fees. And if you want to settle it, they charge exorbitant amounts of money, and then you wring your hands. Is it better to settle or fight? So that's one of the problems. And then you settle. You hope you're done, and what happens next season? They're right back at you for a similar sort, or a violation that's morphed again. And the frustration, I feel the frustration on a relatively constant basis from you guys about this. Having said that, these laws have been around a long time. They are important laws. They protect employees. Courts enforce them. You got to pay minimum wage. You got to pay wages correctly. Nothing I say here today is meant to say that you don't have to follow these laws. You should follow the laws. But when you get these sorts of lawsuits, we have a way now to minimize impact with respect to them. The problem continues in that they're detailed. These laws are detailed. They're difficult to comply with, easy to make a mistake. I see this not just in the landscaping industry, but I see this throughout, all of my clients. It's very easy to make mistakes. I see very few employers that have a wrong or ill intent to not pay correctly, whether it's off the clock work or deductions, anything like that. They just make mistakes because we're human, and that's what happens. So, that's the problem. Then the other problem we've talked about, predatory plaintiffs' law firms. I'm not going to name names. You all know who they are. We know who they are. We know what they do. We know how they do it. We have a wealth of information about them and what their tactics are. They file their class action lawsuits in either federal or state courts, even if there are little or no damages, and then they're off to the races looking for, and then you have to hire your lawyer, and you have to make those business decisions, because essentially that's what these are. These are business decisions, how you minimize costs. You're either going to pay the plaintiff's lawyers, or you're going to pay your own lawyer, and there's processes in court, and it's not fast, it's slow. People have rights, and judges want to give them their day in court, so it winds up being expensive. So that's the other problem, as I term it. But then there's another problem. Back in approximately 2 years ago, Scott and the ILCA sent out a survey and to get some data on this, and it just kind of highlights and solidifies the problem that 100% of the landscape contractors surveyed have been sued. 100%. 20% of those landscape contractors surveyed have been sued more than once. Big number. and then 100% of the landscape contractors surveyed settle their cases before trial. Okay? None of that surprises me because I'm not aware of a single one of these cases in this industry that has gone to trial. They all settle because from a business standpoint, that's what makes the most sense. But we want to dramatically eliminate all of those numbers and bad outcomes. So what are the type of claims from the surveys? Improper uniform deductions, improper tool deductions, off-the-clock work, not paying for driving time, not paying correct overtime rate, the number of hours worked, improper lunch breaks. Now, again, I'm going to repeat something important. It's important that you follow these laws and try and reduce or eliminate violations of the law, because it's not like they're going to go away, and people are entitled to be paid for their work. If they work overtime, they should be paid for it. If they're working before the shift starts, they should be paid for it. That's what the law is. But there should be proper procedures to address this. And I've talked to a lot of landscape contractors, and if people have questions on that, they can call me, or they should call their outside counsel or consult with the internal HR, internal counsel, because there's better processes and procedures, best practices, if you might. But you can have best practices, but they need to be implemented at the ground level between the supervisors. They need to follow that. So something for you to think about as another way to take care of the other problem. So what were the solutions, prior to today and talking about this EPIC system? Well, fight a costly court battle over a class action lawsuit. I know that I'm sure that some of the people listening here today have done that with varying degrees of success and varying degrees of cost. What happens 100% of the time, at some point people surrender and they settle, and because they don't want to continue to have the fight and the cost of legal fees. Neither of these is a good option. Fighting the battle, surrendering and settling quickly, or settling after battling for a while, they all just leave a bad taste in your mouth. And I know that many ILC members have used either both of these strategies without success, and nothing but absolute frustration. Absolute frustration. So, better way forward. This case, class arbitration with class action waiver. So there was the unsettled legal question before this case was whether an employer could require its employees to sign a document waiving their right to go to court and arbitrate an employment claim. So that's the first one. And the second one was whether an employer could require its employees to waive their right to join a class action arbitration. So the first question, this was going around for a while. And I'll skip around a little bit. There's a federal law that's been around, I think, since 1925 called the Federal Arbitration Act. That's 1925. It's a long time ago, 90 years, almost 100. And what that law says is that parties can enter into an agreement that says, we can agree to arbitrate instead of going to court. All right, seems pretty straightforward. There's a number of other U.S. Supreme Court cases from the highest court in the country that's enforced this. But lawyers on the other side are smart. They tried to chip away at this doctrine, and most recently there were courts on both sides of this issue, and it came about with respect to, believe it or not, the National Labor Relations Act. And the NLRB that enforces the National Labor Relations Act said that it was a violation of that law to have people sign arbitration agreements and waiving class action cases. Other courts disagreed, said, no, that's not a violation. And that's how we got to the U.S. Supreme Court on this case. And I was always confident that it would come out this way. But again, the courts move slowly, and it's taken several years. But finally, we're here, and we have good answers to both of these critical legal questions. So, so like the EPIC Systems case is ruled categorically that we can enter into arbitration agreements with our employees that says they cannot go to court. We go to arbitration. And the court ruled categorically again that in those agreements, we can have people sign away their right to engage in a class action lawsuit. So what does that look like? If an employee has a dispute over a deduction or wasn't paid, overtime properly, they can file for arbitration. And we'll talk a little bit more about what that looks like and what that means. But that, employee A has this dispute with company A, and he files for arbitration, and his case is heard. But it's a single case. Now that person may be owed $25. It's a $25 case, and you can decide to whether, if he raises that claim, you can just write a check and be done for that one person. But it's not 25, or $100 times your entire workforce for the same violation, where the plaintiff, and plus, where the plaintiff's lawyer is trying to continue to make that into a bigger case than it is. It's a single person. That's one of the big differences. And it's not in court, it's not public, it's private. So why is this a better approach, in my view? And not just my view, it's like most defense side lawyers. No drawn out court battles. In these sorts of cases would be very fast. They're not complicated. They just get complicated in court because of those court rules, and they get drawn out because of the plaintiff's lawyers, so they can run up their fees, which they inevitably will look for. So it is shorter. Frankly, most of these cases will never be heard in arbitration because those lawyers have less interest in a single employee case. Their damages are dramatically less. No lawyer is going to take a case where the damages are $25, $100, $1,000. I mean, they're looking for, mid 5 figures into 6 figures for damages. That's where they get interested. So, another reason why it's a better approach. Only a really motivated employee with real damages is going to file for arbitration. Let's take uniform deductions. They know they're going to get amounts deducted for uniforms. They get their uniforms. They may not like it, but they know about it. They're not going to do anything about it. So most of these cases just will go away. Because you see, on the slide, the practical impact, likely that this problem will substantially go away. And I talked about faster resolution, and because they're faster, and we'll have fewer of them, there'll be significantly lower the legal fees for your lawyers, and to have to pay if there's a case and someone takes it, and for the other side. So, I mean, these are all significant in my view in terms of why this is a better approach. Why was the approach not used before? Talked about this. Legal issue was unsettled. I already talked about the Federal Arbitration Act. What has changed now? I talked about that. The U.S. Supreme Court, highest court in the land, has ruled arbitration in this context with employers and employees will be enforced, and it will also be enforced with respect to waivers of class action claims. So you can have a document that just has individual claims on it. So, let's talk about this Epic Systems case. So it was decided on May 21st. Very recent. The issue, whether an employer can have employees waive the right to go to court individually or in a class action. Second one, require employees to individually arbitrate employment claims. The answer to both was emphatically yes. Now, what does this mean? This is now settled law. Since the Supreme Court, the U.S. Supreme Court is the highest court in the land, the other courts are all lower to it, subservient to it. They must respect and enforce agreements to arbitrate, and the parties' chosen arbitration procedures. So what that says to employers in the United States is if this is an issue for you, that you should have agreements in place, and we'll talk about that in just a little bit. But you should all seriously talk internally and with whatever professional advisors you have, legal, non-legal, HR, business folks, about implementing this sort of program with class action waivers to get out from under this. But there's always some caveats, and the first one I've mentioned already. This is not a license to not comply with employment laws. That'll just cause issues. So you still need to have good hygiene in that area. So keep that up. I also expect that plaintiffs' lawyers will challenge whatever you implement. Court battles may not be over, But the court battles are going to be more around process and procedure, as in my view, as opposed to whether these are lawful. What they're going to try and do is pick away at each time there's a case. They'll say, well, this agreement wasn't good, that agreement, this provision in the agreement wasn't good, that one wasn't good, employees' rights were not respected, this isn't fair. But, you know, we see a lot of this in California, and I'm sure that doesn't surprise anybody. So we're kind of predicting a little bit from what we have seen over the years in California, but this case is still new. There haven't been any cases filed in Illinois yet trying to throw out an arbitration agreement. It is possible. I don't think it's likely that they'll get thrown out, especially if they're drafted correctly. But that is a caveat. The third caveat I have here is that there was quickly some noise from the Illinois legislature that they may pass laws addressing this issue. That maybe they say these things are illegal, or in California there's a private right of action called PAGA, P-A-G-A, which is a private attorney general action, where that tries to get around this. You know, I have some thoughts about that in drafting the documents. We've kind of addressed this. You know, if the Illinois legislature passes something on this, I think that will be a pretty big fight. You know, we all know that our legislature down in Springfield is a bit odd. So, you know, no predictions on what they'll do and what they won't do. We have, you know, governor's race that may have some impact on it also, but just it's a future caveat out there. So, you know, what I would recommend to, and I have been recommending, is that for your 2019 season, because, you know, 2018 is kind of almost in the bag already, all of your employees should sign an arbitration agreement with a class action waiver. You have plenty of time to get this in process. So, I mean, that's what you should do. Now, you know, another downside is that theoretically, if and some plaintiffs' lawyers in other contexts and other industries have done this, I don't really see this happening in the landscape industry, but, you know, I mentioned it anyway. If they thought that one of the landscape contractors did something wrong on a class-wide basis, and you had 100 employees, they could file 100 individual arbitrations. That would be a big pain, and that would be expensive. You know, but that would also be a ton of work from on their side. And my experience is that they don't necessarily like to work all that hard. You know, so it could result in a lot of individual arbitrations. Arbitrations can also be expensive, but in a different way. You have to pay for the arbitrator, and it's usually like an hourly fee, and that's not nothing over time. And there's administrative expenses from the firm where you get the arbitrator's firm, and that's not nothing. So I don't want you to think that it's virtually cost-free, but it's still dramatically less than going to court. There's still some discovery. Those of you who've gone through this, you know, there's discovery. You got to produce documents, sit for depositions. There's still some of that in arbitration, but it's a bit more limited. So on balance, it's still much better. But, you know, there's still some caveats to it that, you know, I want you to be aware of. So how do we get this going? You need an arbitration agreement with the appropriate waivers. We have certainly drafted our form that we think works real well. It's long. In fact, when I ran it by Scott, he was like, "Whoa, this is pretty long." I said, "Yeah, it is." Why is it long? Because I do expect that these things will be challenged. So we have to try and predict everything, that all the arguments that they could raise, and make sure that we deal with it in our document. You know, understand that we are asking employees to waive important rights: the right to file a class action, the right to go to court. And if we're going to ask them to waive this, we have to fully inform them, because if we don't, a court's going to look at this and you know, and say we procedurally didn't do what was right. We weren't being fair and honest with them. And then couple the fact that many of your employees, their English is not the best, and some of them, their reading and writing skills are not the best. I mean, you have to have this translated into Spanish or any other language so they can understand it. But that's not that big a deal. I mean, having a document translated properly is not that hard, and I don't recommend that you do this yourself with respect to translation. You get a proper translation firm. We basically have one on retainer. We do this all the time because we want to be able to have someone who's trained as a translator to translate this critical document. So it is long, but we think that we have it situated properly. You do this at the beginning of the employment relationship, so beginning of when they sign all the other papers for the 2019 season, that's when you do this. It's mutual. And now they're not going to sue you in court, and you're going to agree not to sue them. But let's be honest, the employer rarely has any lawsuits it wants to file against, an employee. So I'm not overly concerned about that. We have to make sure that the costs of the arbitration are covered completely by the employer. That's one of the procedural things that courts will look to, because if you go to court, you file, I think the filing fee is like $250. After that, the rest of the court process is free to the employee. If we're going to ask them to go to an alternative way of resolving a dispute, we can't make it more expensive for them. They have to be in the same place financially, so we have to cover those costs. And again, we're going to waive the right to go to court for all types of employment claims, and waive the right to be part of a class action or a collective action, which are really the same thing. They're two different words for two different statutes. Collective action is the federal law, class action is the state one. We put in the form that if the employee wins the arbitration, he can still receive the same damages if he was in court, and that's pretty much a requirement. We can require them to go to arbitration, but we can't require them to get fewer damages or different damages. So if they won, they can still get damages, and they can still get attorney's fees if awarded by the arbitrator, just as if they were in court. But again, an individual case is worth not that much money, and I think we would realize pretty quickly that if someone filed for an arbitration, we'd say, well, what do you think you're owed? I'm owed $25, I'm owed $100. You're just going to write the check, most likely, so as not to have to deal with it, and then it goes away and you don't have these costs. The agreement also sets out the arbitration process, which arbitration firm you're going to use. There's really just two large ones. One is AAA, American Arbitration Association. The other one is JAMS, G-A-A-M-S. Those are the two big ones nationally that virtually everyone uses. They have stocks of arbitrators based on skill sets and locations, and the parties will just choose an arbitrator from there, and they do the administrative work. One thing we have also put in the agreement, at least our version of the agreement, that employees can opt out of the agreement within 30 days. Why do we put that in there? You may say that just takes away all of the impact of the agreement. First of all, no one ever opts out because they just don't. That's just the way life is. But secondly, we don't want anyone to raise the argument in court saying that they didn't have the right to opt out, and in fact, that helps our argument saying, of course this was fair, because all they had to do was opt out if they didn't want to do it. So it wasn't, a strict sort of thing. We're giving them another chance to opt out, but again, no one ever does. That we've had, literally no one does. Some other suggestions, before you get to a situation where it's an arbitration, I would recommend that people implement policies where employees can raise issues at work with either their supervisor, HR, their managers, their owners, whatever works for you. It should be tailored to your company, but they should be able to come to somebody without fear of retaliation to address issues so that they could, so they can have them resolved. I think that goes a long way towards avoiding that. That's 30 plus years of HR, scholarly work through college, working as an HR professional and also being an HR lawyer for many years. I think that works well. This system I'm suggesting could be as formal or as informal as you want. It could just be someone coming in and saying, hey, I don't think I was paid correctly, and you saying, hey, what do you think is wrong? Let's look at your payroll stuff, together, and you could say, hey, I wasn't paid for that overtime. Oh, it's on your next check because the payroll period cut off, and boom, you're done, and that's easy enough. Or you could have someone write it out. My guess is the informal approach is better, but if you're a larger company, you may want it more formal, and that's fine. Yeah, I think it diffuses problems and issues before they start, but it also provides documentation to the company if an issue arises later, like what the issue was and how you resolve. Other things to think about: better onboarding training. When people come in, explain to them how, if they have an issue, how they can resolve it at the company. Better supervisor training, that if someone comes with you with an issue, if they can't resolve it or they're too busy to resolve it, they should go to HR, accounting, their boss, something like that, not just ignore it. And again, the good old review your policies and procedures. Be honest with yourself. Where are your policies and procedures weakened? Everyone has a weak spot. Don't be shy about it. Find it, address it, and you do all these things, you dramatically minimize the likelihood of having a legal issue. And I would say implement an arbitration policy, like we've been discussing. Get professional help to implement this change and other changes. And as I said in the beginning, this is a real opportunity. We really think that this is a way to virtually eliminate this. Dare I say that we will substantially put out of business some of these law firms trying to make a living on the Illinois landscape contractors. Yeah, I think that's a possibility that could happen. So, this was relatively fast, short and sweet. I thought maybe some of you guys would have questions, in the chat box, and we have had none. Does anybody have questions? Because, I certainly left a substantial amount of time for you guys to ask questions about it. If you have questions, please type them in, or give me a call, or shoot me an email on my business email that was on the first slide. This is something that you should absolutely think about internally, and you should absolutely try and implement. I think that you will be very pleased with the results. So, any questions from anyone? Otherwise, I'll turn it back over to Scott.
Looks like we have a question.
Yeah. I just need to put on my glasses so I can read it.
I can read it as well.
Yeah, if we allow employees to opt out but yet make it a condition of their employment, how do we handle if they opt out of the arbitration agreement? Good question. If they opt out, it's as if it didn't exist, because what's a condition of employment is that they sign the agreement, and then we're giving them, as part of that agreement, the ability to opt out. You don't have to give them the ability to opt out. It's just a procedural way to show that you, as the employer, are being fair, and that they can't say that they, had no choice in this, because they do have a choice. But you don't have to do that. Another question: would you recommend including the agreement in the employee handbook? No, I would have a separate agreement. The reason you can mention it in the employee handbook that we require all employees to sign our standard arbitration policy. And the reason I would not put it in the handbook alone is because handbooks always have disclaimers that you can change it, that this is not a contract. And if it's not a contract, it's not binding. So we don't want to put anything this important in the employee handbook. We want it separate. So it is a binding handbook, because there's a 1985 Illinois, as opposed to U.S., but Illinois Supreme Court case called Del Deleo. Why I remember that, I don't know. And that was when the Illinois Supreme Court ruled that employee handbooks in Illinois, if they have disclaimers, are not contracts. But it makes perfect sense. So no, you want it to be separate. I know that Scott responded to one question that a copy of the presentation it's recorded and posted for the ILCA members. Now, other thoughts, questions? Here's another question. Given the layoffs and hiring cycle, must these agreements be signed every spring for returning employees? I think that I would be safe and do that because I know people handle it differently. That when people leave for the season, sometimes they're terminated and they receive unemployment. Some people work the snow season, but I would not want to make anything this important subject to an argument that, well, this is good. We signed this in 2019, but then I was terminated. I came back in 2020 because you're going to have them sign new forms, new tax forms, and other things. Just put it in a pile of forms to do that. So I would have them sign that each year.
Are there any more questions from any of the attendees?
I think I've addressed everything that I have so far.
All right. Well, great. We have another question.
Yes. Someone's asking me, like, basically paraphrasing. So, like, what's the deal with our forms? Just give me a call or contact me. Yeah. I mean, I don't want to be crass about it, but yeah, we're in business. We're finalizing the form. It's not completely done, but we're pretty close. And if you're interested in talking further about implementing a policy and having us help you, just give me a call. This is not from the lawyer end on my side. It's not an expensive proposition for you. For me, it's more important. I will get a lot of personal satisfaction just seeing that this situation for you, for the ILCA members, gets corrected. But yeah, just give me a call.
All right.
I think that's it.
Last call for questions. David, I really want to thank you on behalf of the entire ILCA for walking with us along this process. I know we kind of had we were in arrested development for a while where
we sure were.
We're just waiting for the Supreme Court, and sometimes that can be waiting is the hardest part. Now I think it comes down to the idea that just because this has been these agreements are now constitutional and enforceable, the companies now have to go out and actually get them done and get them put together and signed. That the road has been paved, but now you need to walk down it. And
what I usually say is this is where the rubber meets the road. I mean, we're in the best place legally that we could ever hope to be at this moment in time. So, the companies have to step up and take advantage of this development and have their employees sign the agreement, have them translated, do it that way. And, I think I will predict that this problem will substantially go away, because when these plaintiffs' lawyers see these arbitration agreements, they're going to say, oh, can't go to this company. They're going to look for the weak links. The weak link is going to be the company without these agreements.
And I know that the companies who have had to deal with these aggressive labor attorneys will be the first ones. They're probably already, as we're going through this webinar, already starting to put some thoughts down on paper and lining up their policy. If you have never had to go through one of these, trust me, they're no fun and no picnic. So I would urge everyone to take the time. I know that we're right now in that first lull of the landscape season. But obviously we're on the clock as you look forward to hiring next spring. But I think these should be integral parts of every company's hiring process, knowing the exposure that many of our members have had in the past. But once again, David, I want to thank you for the time you spent with us today and the time you've spent with us over the last 18 months. And I know that you're going to be a vital resource for our members moving forward.
I hope so. It's always my pleasure to work with the ILCA and its members.
Well, thank you, everyone. And on behalf of the ILCA, have a safe second part of your season. And please contact either me or David with any questions.
Take care. Thank you.